are part of the story of race and of the U.S. Supreme Court, and they are part of the story of this book. African Americans, the largest minority until the 2000 census, are at the center of this book because so much of U.S. national history and so many Supreme Court cases have focused on slavery and Jim Crow and their aftermath. This book, while covering the entire United States, often looks toward the South, the place where most African Americans have lived for most of U.S. history. Just like the notion of race, the Supreme Court can also be vexing and perplexing. Even if its mission were simply to call balls and strikes, as John Roberts suggested in 2005 when he was a nominee to the court, how does that work when the umpires keep changing and each new set of umpires can redefine the strike zone, change the number of balls and strikes each batter gets, and even change decisions by previous umpires? Put together the vexing concept of race with the perplexing Supreme Court, and you have this book. Fusing the perspectives of a historian and a lawyer, the book views U.S. racial history through the lens of the Supreme Court, from slavery in the colonies to the present day, and even projects a glimpse of possible futures. Race and the Supreme Court are at the center of this drama, but major roles are also played by two other actors, time and law. Time is fundamental for understanding race in the United States. African slavery and Jim Crow prevailed for 300 years, and they have been gone for just over 50 years. If we count a generation as 25 years, then American history has consisted of 12 generations of white supremacy and barely 2 generations of trying, sometimes more aggressively than at other times, to overcome it. Law, including government action, has always been central in maintaining racial control and racial separation. Law defined enslaved workers as a commodity, but also had to grapple with the reality that they were human beings. As a result, both enslaved and free black people, in all 13 original colonies and then in the slave states, were regulated by reams of laws that also established a relationship between color and crime. Law also detailed segregation codes and discriminatory rulebooks in 20th-century federal housing and mortgage agencies. The law has played a crucial role in events concerning other races, including Native American removal, Chinese exclusion, Japanese internment, Latino discrimination, and more. In the category of law, of course, is the work of the Supreme Court, interpreting law and thereby deciding what the law means. The role that law and government action have played in spreading race discrimination and molding attitudes of race prejudice has been virtually erased from public memory by a form of national amnesia. In 1849, this amnesia afflicted a Massachusetts judge who said race prejudice is not created by law and probably cannot be changed by law. Today, it afflicts those, including some Supreme Court justices, who think all white suburbs just happened by themselves. George Orwell, as usual, had something to say about this. The past was erased, the erasure was forgotten, the lie became the truth. But time and law can also undo the inequality they created. That undoing is the role of the 13th Amendment, adopted after the Civil War to abolish slavery and bring universal freedom throughout the land. That amendment was not a one-time historical event that became irrelevant once the institution of slavery no longer existed. The 13th Amendment continues its